Good morning, all, and welcome to this meeting of the Election Compliance Audit Committee. We have a quorum with members Bergeron and Huang and myself. Vice Chair Bedard and Member O'Callaghan have sent their regrets. Are the minutes of the December 16 Election Compliance Audit Committee confirmed? Confirmed, thank you. And the committee has received two communications from the city clerk. One, a memorandum with respect to the review of contributions to candidates on preliminary and supplementary financial statements, and the other, a memorandum with respect to the review of contributions to candidates for the 2019 Rideau Rockcliffe by-election. The rules do not expressly provide for motion to receive the communications. They're simply listed on the agenda. Unless anyone has a question or wishes to make a comment on the communications. If not, the communications are simply listed on the agenda. Before considering the audit report, I'd like to make a few brief remarks. At its July 17th meeting, the committee granted an application for a compliance audit with respect to candidate Laura Dudas, her election campaign finances. This decision was made because the information before the committee at that time led it to believe that there was a reasonable probability that there had been a breach of the campaign finance provisions of the Municipal Elections Act. On September 30th, the city appointed an auditor, Marco Perron of Raymond Charbot, Grant and Thornton, who is with us today, to carry out a compliance audit of the candidate Dudas election finances. The auditor has now completed his investigation, and his report has outlined a number of apparent contributions of the Act by the candidate. The committee is meeting today to consider the auditor's report and will, based on that report and any presentations heard today, decide whether to commence a legal action, legal proceedings. As I usually do, I repeat that neither this committee nor any auditor has the right to determine whether a contravention of the Act has in fact occurred. That jurisdiction rests entirely with the court. The parties may, if they wish, make submissions to the committee on today's item and answer any questions that members may have. The committee will then recess the meeting to deliberate in private. It will either reconvene to issue a decision and reasons by motion. If the committee decides to commence legal proceedings, the city clerk will work with the city solicitor to carry out the required steps to implement the committee's decision, including the retention and referral of this matter to an independent prosecutor. Once the prosecutor is retained, they will be required to review the records relating to the matter with a view to being able to make an informed exercise of their inherent jurisdiction, exercise of prosecutorial discretion on the question of whether or not to pursue the prosecution. If anyone wishes to speak today, they should have filled out a request to speak form and submit it to the committee coordinator. If anyone has not filled out a request to speak and wishes to, please fill out the form and provide it to the committee coordinator. Let us begin the agenda then. The consideration of the auditor's report concerning the campaign finances of candidate Laura Duda for Innes Ward for the 2018 regular election. We currently have the following list of speakers. The Gregory Meads, with the legal firm of Weiss and Hunter, and the candidate Laura Duda. You each have 5 minutes to make your presentations. I'll call first on Mr. Meads. You may proceed, sir.
Good morning, Mr. Chair, members of the committee. I provided you this morning with a copy of the submissions that I'll be making this morning. I wanted you to have a hard copy to take away with you when you're proceeding with your deliberations of the matter.
Excuse me, Mr. Meads, we've been advised that, and it seems to make sense, that, and it will assist in your presentation, I think perhaps if we hear from the auditor first so that you know what you're referring to. I think you have a copy of the written report, but if the auditor has additional comments he wishes to make, it would be preferable if we heard from him in advance. I'm sorry. Yes, Mr. Perron.
Thank you, Mr. Chair. So we provided a copy of the report to the committee. Happy to provide just a quick summary of a report if that would be of value, or answer any questions you might have. Summary. So yes, we were appointed to audit the election campaign finances for 2018 regular elections campaign of candidate Laura Dudas. There was a complaint made in this file, so we've summarized our report, and we summarized our complaint in kind of twofold. First portion of the complaint was in regards to 2014 material that was used for the 2018 campaign. That included kind of three I would say, elements to that complaint. One was that 2014 signs were used on public and private property. Two was that 2014 campaign material was used by volunteers. And the third was that 2014 signs were used at the election party. So based on evidence that we had a chance to gather during the audit, on the first area, we did find evidence that signs were used on public and private property. We did not find any evidence that 2014 campaign material was used by volunteers, and we did again find evidence for the 2014 signs used at election party at the end of the campaign. Based on those elements, there was a conclusion that there was an apparent non-compliance for this complaint. On part two of the complaint, which was related to campaign apparel at the campaign launch party, as well as the professional video that was used during the campaign. We proceeded again to gather evidence. Based on evidence gathered, we went and we did a chain of events, so that was, to put clarity in our minds. So the chain of events that we were able to gather was that on May 2nd, a professional video was produced. On May 4th, the campaign t-shirts were printed and picked up. On May 4th, the nomination of the candidate happened. And on May 7th, the bank account was opened, again, based on evidence that was provided to us. So then in regards to both the campaign apparel and the professional video, which represented expenses in the financial reports, Those were incurred before the bank account was opened based on evidence we received, and therefore we judged that there was a apparent non-compliance of the MEA. Our audit also covers the whole of the contribution, so we don't just look at what was complained about, but we looked at the whole of the reports. Again, there were some more minor items that we were found, one on inaccuracy of financial statements, and again, support that was missing for 8 receipts that were expensed into the finances. Again, for both of those, given that we were lacking some support, there appears to be a non-compliance to the MEA.
I have one question for audit. For the last part of this 5 or 6, 7 receipts, how do you find the receipt was, the amounts was provided in the financial statement? How do you find there was no support, there no receipts? Or can you elaborate a bit more on the last part of your report?
Yeah, happy to. So on the last part, so we talked about 8 specific items that were listed as expenses. Again, for all expenses based on the Act, we were looking for supporting evidence for those amounts. There was some evidence provided for a portion of these, which when we received was not legible. We tried to gain those receipts again. We were not able to. There was one that was missing, which is the first one, the Orleans Chamber of Commerce, which we had no receipts for, and the last 2, again, for which we had no receipts, which was the metal signs.
Basically, 3 expenses with no support during your audit.
Yes.
Okay,
So
good.
3 for no support, and the other 5, we did have support. We just weren't able to read it, and we tried to gain new copies of the supports, which we were not able to.
Okay, understand. Thank you.
I wonder, Mr. Barrow, can you tell us with respect to the first complaint, you seem to have 2 conclusions. One that the expenses were incurred prior to a bank account being opened. That's one. Can you tell us on what you based your conclusion that the account was opened on May the 7th?
Yes, so evidence that was provided to us was the details of the bank account. So it's basically a statement coming from TD Bank. On that statement, there's all the transactions that happened one after the other. We can see all the transactions ins and out. And that statement comes with an opening statement of bank opened. And the bank open, according to the official documents that we received, was on May 7th.
That actual statement isn't in your report, is it?
No, it's not, but it's part of our file, yes.
Okay. And a second question relating to the question of the timing of expenses incurred. It's an offense to incur expenses prior to a bank account being open. Is it not also an offense to receive or to make commitments regarding expenses prior to the opening of the campaign period, beginning of the campaign period?
It is our understanding, yes.
All right. And would the expenses that you found incurred prior to the opening of the bank account, were they also incurred prior to the beginning of the campaign period?
Only for one. So for the T-shirts, they were on the same day. May 4th was a nomination date, so those were concurrent, same day. But for the video, yes, it was, according to our evidence gathered, it was shot and incurred on May 2nd, which was prior to the nomination date of May 4th.
Okay. Member Bergeron?
Did you receive, I realize that the video is a non-monetary contribution, but it still falls within the guidelines of goods and services limit. Do you have any indication as to what the video would have cost?
Yeah, invoice was provided for it to provide the commercial value of the video, and it was $800.
And how long was the video?
The video on YouTube, I think, was just over a minute, I believe. But I'm not sure exactly how long it took to produce.
I'm sorry, I didn't hear your answer with respect to cost.
So an invoice was provided, and the value on the invoice was $800.
With respect to the signs, can you tell me where the signs were erected?
Most of our evidence gathered was, I guess, based on interviews that they were made aware that the signs were erected in public and private property. We did do some research online with regards to some Google Maps. The exact locations, I could happily go back into our files later on and come back with the exact locations, but I don't have that on hand right now.
Sorry, do you know how many signs were erected coming from the 2014 campaign?
Again, the number of signs, we couldn't, I guess, get evidence of the total number of signs again. They could have been in other areas that we didn't have actually research showing on Google Maps, but again, from interviews, it was provided that there were evidence that there were signs that were erected in public and private properties through discussions with the campaign team.
And do you know that some were or one or more were located on the street right away, I understand?
Pardon?
Were one or more signs on the street right away?
Street right away.
I think what the chair is asking were one or more signs on public property. I do recall that we did see 2014 signs on private property on Innis and Blackburn, but were there other signs on public property as well? Do you have any information on that?
I'd have to go back to check our records on that.
Can you please?
Sure. Again, I'd have to go back and provide that information at a later date. We'd have to go look through our file.
I wondered, do you know whether, can you tell us whether anyone driving, say, between the candidates' residence and City Hall would pass a sign visible from the road?
So yeah, we can go back on our record. For us, the audit process was more of, was there evidence and knowledge of signs being used? So I'll have to go back. I'm not sure if we have all the information. We tried to gather as much information as we can as a location and where, and going back again as evidence on Google Maps, but based on evidence we have, which was more press coverage, social media, and interviews, it was more confirmed that there was knowledge that some of the signs were being used. But then the exact location, the exact number are not information that was detailed.
Do you know who erected them?
No.
Do you know when they were erected?
So again, during the, some of the evidence indicated that it was used during the campaign, so during the campaign period, and there was some at the, again, based on social media pictures, at the election party at the end of the campaign.
So I take it you've no information how long the signs on the roadway allowance were allowed to remain?
Unfortunately, no. The candidate did confirm in interviews that, and the team did confirm that when they were made aware of signs being used, they tried to take them down. As they were made aware, they tried to address the situation. That was what they informed us, but we don't have the detailed information on the exact location and exact duration.
Thank you, sir. In the absence of any further questions from the members, I'll call upon Mr. Meads again.
Thank you, Mr. Chair. I will briefly address each instance of apparent non-compliance and then speak to the committee's exercise of discretion in deciding whether or not to commence legal proceedings in accordance with the Act and the committee's rules. I'm going to start where you left off, Mr. Chair, with regards to the use of 2014 campaign signs. Just picking up on the questions which you just had, it's quite evident that this is the opportunity for a report to come forward, setting out a case for you to move forward with legal proceedings or not, and there's no direct evidence of where signs were, how many signs were up, who erected them, where they were erected, when they were removed. But most importantly, Mr. Chair, is what the auditor's conclusion is, and what is really relevant here is that the evidence is clear that the candidate or her campaign did not know about and did not authorize the use of those signs on public or private property, and that more importantly, when any instance of such use came to the knowledge of the campaign, the signs were moved immediately.
Sorry to interrupt for a second, Mr.
Yes.
Meads. You had some written comments. Did you wish them to be provided to the committee to introduce your...
Sorry, yes, I'm aware that you have them. I do wish them to be entered into the record for the committee, yes. I believe you each have a copy of those.
The committee members agree? Then your considerations, written considerations of auditor's report will be entered as part of the record.
Thank you, Mr. Chair.
Thank you. Please continue.
With regards to the use of the signs at the party, the evidence is also clear, and as found in the auditor's report, that the candidate had no prior knowledge that those signs were going to be used at the party, and that, more importantly, Mr. Chair, in any event, the signs appeared at the post-election party after the election had already taken place. So, on those facts, Mr. Chair, it's my submission that no conviction would be entered with regards to these items, even if a decision were made to commence legal proceedings. With respect to the campaign T-shirt expense, the audit report states that the campaign bank account was open on the 7th. That may well be the date that the records, the bank statement indicates. But in fact, the account was opened on May the 4th. After filing nomination papers. You have, as Appendix 1, a copy of an email confirmation with the bank confirming that appointment. On May the 4th, that appointment was to open the bank account. The candidate left the meeting with temporary account checks, as well as a campaign account debit card. So as far as the campaign was concerned or had knowledge of, the account was opened on May the 4th, not the 7th. So it would have been appropriate for the candidate or the campaign to start incurring expenses at that date. Further, and in any event, Mr. Chair, members of the committee, the T-shirts at the campaign launch party appeared without the prior knowledge or request of the campaign or the candidate. They were produced by an individual who owns a production company, promotional and printing business, and the candidate later learned that they were brought by that person in hopes that she could convince the campaign to order T-shirts from her. So there was no campaign or candidate request for those T-shirts. They appeared without her knowledge. And those T-shirts were not used by the campaign. They ordered different T-shirts, different design at a later date. So again, Mr. Chair, on these facts, I submit to you that no conviction would be entered regarding this item. Regarding the campaign video, as we discussed at the first hearing in this matter, the video was filmed by a friend of the candidate as test footage. Interesting point, as the candidate has pointed out to me in the video, you may note that she has rather bright, colorful red hair, which she's not proud of and never intended to have that video be used in the campaign. It was never intended to be used. It was test footage, and the video did not become a thing of value to the campaign, and thus a contribution, until the decision was made after filing the nomination papers 2 days later. Just keep in mind, we're talking about 2 days in addition. That decision was made 2 days later to make use of the video. And of course, the candidate, not trying to hide anything, not trying to slide anything through, recorded that in her financial statement, attributing to be on the safe side a rather probably liberal amount as a contribution. Once again, Mr. Chair, I submit to you that no conviction would be entered regarding this item, as there was no contravention. Turning to the additional matters which the audit found, which were not part of the original complaint, there's a reference to failing to record a $20 deposit by the candidate and associated banking fees. Mr. Chair, I submit to you that if all candidates' statements were the subject of the rigors of such an audit, instances of minor errors such as this, errors in accounting and reporting are inevitable. It's an error of no consequence. It's a de minimis error. The candidate made no effort to conceal this contribution. She made reasonable efforts to address it. The amounts in question represent at most a de minimis discrepancy and certainly not meriting legal proceedings. Finally, the last item with regards to the failing to record various contributions. The audit notes 6 instances of contributions from the candidate or spouse which were not provided or legible. In fact, receipts for all of these items were provided. You have copies of them now set out in Appendix 2. Included in there is the Chamber of Commerce receipt and all of the other items that were missing. Perhaps it was an issue of the compression of the electronic files and the decompression process, and they may not have been legible. I don't know. This could have been clarified had the question been raised with the candidate through the audit process. The final discrepancy is with reference to the 2 contributions of signed metal posts by the 2 individuals noted in that section. These contributions relate to iron rebar, which was in the possession of these 2 individuals. It was goods they already had in their garage or accessible to them. And these were in fact loaned to the campaign by the 2 individuals to use during the campaign. So there's no specific invoice amount. The candidate, in an effort to determine an appropriate amount to include in the statement, went to Princess Auto and priced out the cost to actually purchase the same quantity of rebar, the same amount of supplies which are temporarily lent to the campaign. So that's where that number comes from. There is no actual invoice because there was no actual statement from the individuals owning the equipment, and no specific value could be attributed. Again, she put in a liberal, high estimate of the contribution to be safe. So once again, the actual facts relating to these 2 categories of contributions suggest that no conviction would be entered regarding either one. So, Mr. Chair, in total, it's my submission that the facts support the conclusion that no contravention of the Act occurred for which a conviction would result. Of course, it's for the committee to exercise its discretion in determining whether the apparent instances of non-compliance, which remain unproven, justify the expenditure of the city's resources, financial and otherwise, to attempt to secure a conviction, which would, I respectfully submit, result at most in a fairly modest fine being imposed against the candidate. So it's that question of public interest. It is also reasonable and appropriate for this committee to consider the principle and objective of deterrence in deciding whether to commence legal proceedings. I can assure you that candidate Dudas has been humbled by this process and has learned considerably regarding the very demanding standards imposed by the Municipal Elections Act. I respectfully submit that this very public, multi-hearing process has achieved the objective of specific deterrence and public education, and a modest fine imposed following a trial, even if ultimately successful, would achieve little further, save and accept the expenditure of considerable amounts of ratepayers' money to run a prosecution. In light of all the facts detailed above, the particular circumstances before you, the absence of any intent by the candidate to flaunt the requirements of the Act, and the absence of actual knowledge regarding the actions of others, which form the basis for some of the alleged acts of noncompliance, I respectfully request that this committee exercise its discretion in deciding not to commence legal proceedings. Thank you, Mr. Chair.
Thank you, Mr. Meads. Do members of the committee have any questions for Mr. Meads? Madam Bergeron?
I actually have a question of the clerk's office. For this candidate's campaign, what was her campaign period, please?
Mr. Chair, Ms. Dudas's campaign period began on May 4th, 2018, and concluded on December 31st, 2018.
Okay, so then when Mr. Mead indicated the 2014 signs at the election party afterwards, it didn't really matter because the election was done, she was still within her campaign period.
Absolutely, it was within the campaign period, yes.
Number one.
So I have a question for the candidates. As you stated, the candidate did not aware of and did not authorize the use of 2014 campaign sign. I wonder, at the end of 2014 election, who physically keep those signs?
This question is for the candidate?
Yeah.
I'm sorry, could you repeat?
So who physically has those 2014 campaign sign after election, 2014 election? Who kept?
Who kept?
Yeah.
Oh, myself and my family kept several. It was to go through an election is an incredibly it's something as a candidate, it's very important to you. So you might keep some of those as mementos. You know, for myself and my family, we kept several of them. My children decorated several for a reminder. You know, I know my husband, strangely enough, used some under one of our classic cars to change the oil with. We actually have one in our side shed right now, keeping the roof from the raccoons. So, I mean, it's coroplast. I didn't want to just throw them in the garbage. It's not great for the environment, so I did keep a couple for mementos, but also for use around the house. None of them were in particularly great condition, and I believe, as I said to the committee in one of the previous committee sessions, you know, we had held on to several just for memento purposes.
Okay. So it confused me when you if you kept all the signs and you are not aware of, did not authorize use 2014 sign, how can somebody took those sign, put on the property and used for the election day party?
Forgive me, I misunderstood. I know that in the instance that was brought forward, to which the committee had been provided the photos, that was a supporter who had held on to those signs and had kept them from the 2014. And as soon as my team had discovered that he had put them up on his own property, we then went and asked him to remove them, which I believe I said at the previous committee meeting.
Okay, good. Yeah, thank you.
Mr. Meads, I'm not sure whether this question is for you or the candidate. I'll let you decide who can best answer it. But I was wondering, with respect to the T-shirts, and when or if expenses were incurred with respect to the T-shirts that were worn on the nomination day, I wonder, was the person shown in the auditor's report as campaign manager 1? Was he the person that produced or asked for the T-shirts to be made?
I'll let the candidate correct me if I'm wrong, but my understanding is that nobody asked for those T-shirts at the campaign period to be brought, but I'll let the candidate correct me if I've misstated that or misunderstood your question.
Well, the T-shirts that were worn by campaign supporters at the nomination day had to be ordered by or made by someone. Was it the campaign manager?
He did not. No. So
It was not by the campaign manager. As I indicated, it was by a friend of the campaign or someone associated with someone who happened to have a business, who brought T-shirts of their own volition without the knowledge of the campaign in an attempt to sell T-shirts.
But no one with the connection with the campaign?
No one with connection with the campaign requested them, is my understanding.
And the bill that was subsequently part of the financial statements for T-shirts, did that include any amount for the T-shirts that were prepared and used at the nomination launch?
My understanding is that the T-shirt expense recorded in the financial statement is for the T-shirts that were actually ordered and used by the campaign during the campaign, which were different than those T-shirts which were brought by an individual to the campaign launch party.
And I take it your submission is that those T-shirts that we saw worn by campaign supporters on the nomination day weren't used on any other occasion?
That's correct. That's my understanding. Not to the knowledge of the candidate or the campaign. Just as the candidate or the campaign could not control whether or not people used old 2014 signs. All they could do is, when they knew about it, to take action.
And do you know whether they were, can you tell us how long they remained up, the signs?
The 2014, the instance of the I don't know if there's any way of knowing how long they were up. All we can say is that as soon as the candidate was aware that they were up, that they were removed, which is exactly what I submit to you the spirit and intent of the legislation would require.
And I take it these, they didn't go up with the knowledge not only of the candidate, but of her campaign managers, either manager 1 or manager 2?
Sorry, it notes that in the audit. We weren't aware of them going up. Sorry, neither myself nor the campaign managers. It mentions that in the audit documents.
The records that were produced here today as part of your submission, Council, were they provided to the auditor?
I'm advised that all of the documents which we have attached to Appendix 2 were included in electronic documents that were sent to the auditor.
And do you know when?
Over the past couple of weeks, I understand. I was not involved in the back and forth between the campaign or the candidate and the auditor, but that's my understanding.
Any further questions?
Yeah, just one on we're back to the T-shirts again. So the T-shirts were brought to the launch party without the candidate or the campaign knowing. People were wearing the T-shirts. Was the candidate in pictures with those individuals wearing those T-shirts at the launch party?
We don't know. I don't know. The candidate doesn't know.
I seem to recall a picture in the submission where the candidate was standing in front of individuals wearing her T-shirts. I just seem to recall the original submission.
That's possible.
Yeah.
Yeah.
If I may, Mr. Powell, you heard my question to Mr. Meads concerning the records. The records, you have a copy of this written submissions and a copy of the records
Yes, we just
that
received
I'm referring to. Can you tell the committee when they were first received by the auditor?
So based on the information we received, I haven't had a chance to go through it in detail, but in our understanding, the first TD letter, as well as the first Orleans Chamber of Commerce, was not part of the documentation we had received. The Tim Hortons bills that are printed here could have been provided through USB key. We had a chance to go back and forth on the fact that we were not able to read those documentation, so this would be the first time we would see this clarity of invoices.
Are those records directly reply to some of the records that you state in your report that were not produced?
Can you just please repeat the question?
Sorry, with the records that are attached to the candidate's submission or lawyer's submission, did they reply or are they the same as those records that you state in your report were missing?
So we haven't had a chance to look at them in detail, but the Tim Hortons bills do seem to align to some of the missing information. Again, the Orleans one matches the amount as well. Again, this would be the first time we see this, and the TD documentation would seems to be an appointment for a confirmation of an appointment. Is new information to us, but again, based on official documentation from the bank, and based on the bank, they state a date at which the bank is open was May 7th in our records.
Now that you have seen the records produced by Candidates Council, are there still records missing that you've identified as missing in your report, not provided?
Well, yeah, to answer that question in detail, we would have to go through in detail those records. We'd validate the dates, the amounts, match them back to the contribution to make sure that they're the right receipts for the right amounts. So that work has not been done, but assuming that the dates, the amounts, and the description all match what's missing in our report, then the only thing missing, if these records are accurate, would be supporting a documentation for the metal documents, which we stated as signed metal posts.
But is it your evidence, your thought that these documents weren't produced at the time you were writing your report and within the campaign, finance campaign requirements?
Yeah, to our understanding, the first two documents were not provided during the audit. The last documents could have been. We did acknowledge that there were some documents provided that was not legible for us, which seems to be receipts from Tim Hortons and these receipts. We had a chance to go back and forth with the candidate multiple times to try to get a clearer copy of those documentation, and we were not able to obtain them.
And the opening of the bank account, how's that jive with your understanding of when the bank account was opened?
Well, we don't deny that there's multiple steps that are taken before opening a bank account. There needs to be provided information. There needs to be exchange of information between the bank and individuals. We, as an auditor, go on solid evidence that we can gather in our file. So we always get from the banks their position of when the bank was officially opened. According to our records, that was May 7th.
If you'd seen the report produced, or the document produced today from council, appointment information, I think it's the first document in his report. It's a statement from the bank. Would you, from an accounting point of view, accept this as a document showing when the account was in fact opened?
Again, to our understanding, this represents a confirmation of an appointment. If I read through this very quickly, based on actual opening of a bank account, we again ask banks for confirmation of when that bank account was opened. According to the official bank records with their letterhead, that was May 7th.
Mr. Chair, if I can just make one comment with regards to that. Keep in mind, of course, that the candidate left that meeting with checks for the account and a bank card for the account. As far as the candidate or any one of us would be concerned, your account is open if you have a bank card.
Thank you, Mr. Meads. Any further questions by members? Questions of our legal counsel or the city clerk? No further. If there are no questions, the committee will adjourn to deliberate in private. We'll return and give our decision and reason for decision in public in approximately 15 minutes.
More than 15.
or more. The committee will now resume, having reached its decision. Member Bedard, would you, Bergeron, would you kindly read the committee's decision and reasons?
Moved by myself, be it resolved that the committee issues the following decision and reasons. Upon receiving the compliance audit report with respect to the election campaign finances of the candidate Laura Dudas from the appointed auditor, hearing the representations and/or reading the written submissions and documents submitted by the auditor, the candidate, her representative, and city staff, this committee hereby decides to commence legal proceedings against the candidate for an apparent contravention of the provisions of the Municipal Elections Act 1996 relating to the campaign finances for the following reasons. The auditor's report identifies a number of apparent contraventions of the provisions of the Municipal Elections Act financial campaign provisions. These apparent contraventions were supported by the auditor's extensive examination of documents and witness interviews listed in the report. The apparent contraventions are too numerous and give the committee concern that the values of public accountability and transparency have not been respected during Ms. Dudas's campaign. The apparent contraventions of this number are inconsistent with the maintenance of public confidence in the integrity of the electoral process. The candidate's stated ignorance of the various expenses incurred for her campaign's benefit undercuts the requirement of candidate accountability, which lies at the heart of the Act's election campaign finance provisions. The committee directs the city clerk to work with the city solicitor to implement this decision, including retaining external legal counsel to have all the usual power and authority of a prosecutor for the purpose of the legal proceeding.
Thank you. All in favor? Unanimous. Are there any inquiries by members of the committee? There being no inquiries, do any members have any other business for the committee's consideration? Seeing none, we can now adjourn. Is the motion to adjourn carried? Carried. Thank you. Meeting's adjourned.
No, I took a pass.
Okay, very good. Public transit